detained leader of the indigenous people of Biafra, IPOB, Nnamdi Kanu, has asked the Federal High Court to stop the delivery of its judgment scheduled for November 20th and the terrorism charges against him. In addition, he is seeking an order setting aside all proceedings and orders made by Justice James Omotosho in charge No. FHC/ABJ/CR/383/2015 for want of jurisdiction and violation of constitutional supremacy. Justice James Omotosho of the Abuja Division of the Federal High Court has fixed November 20th to deliver the judgment in charge No. FHC/ABJ/CR/383/2015, brought against him by the federal government. But in a motion dated and filed on November 10th, Kanu is seeking an order arresting the delivery of the judgment on the ground that the proceedings were conducted under a repealed and non-existing statute and in disobedience to the Supreme Court directive contrary to Section 287(1) of the 1999 Constitution. The motion signed and filed by Kanu was brought pursuant to Section 6(6)(b), 36(6)(a), and 12, and 287(1) of the 1999 Constitution, Sections 220, 233, 259, and 396 of the Administration of Criminal Justice Act 2015, Sections 122 and 127 of the Evidence Act 2011 and Section 76, 1(d)(3) of the Terrorism, Prevention and Prohibition Act 2022. The motion is further urging the court to declare that by virtue of Section 287(1) of the 1999 Constitution, the trial court was constitutionally bound to give effect to the Supreme Court findings that Count 15, now Count 7, does not exist in law, and its failure renders all subsequent proceedings null and void. Kanu is equally seeking an order of court declaring that the failure of the trial court to take judicial notice of the repeal of the 2013 Terrorism Act, contrary to Section 122 of the Evidence Act 2011, vitiates all steps taken thereunder. A declaration that by virtue of Section 76, 1(d)(3) of the Terrorism, Prevention and Prohibition Act 2022, the Federal High Court lacked jurisdiction to try him in the absence of proof that the alleged conduct constituted an offense under Kenyan law or any Kenyan judicial validation or extradition law. He wants a declaration that his plea purportedly taken on March 29, 2025 under a repealed and non-existent statute and in violation of Section 220 of the Administration of Criminal Justice Act, ACJA, 2015, conferring jurisdiction on the trial court. Meanwhile, the Nnamdi Kanu Global Defense Consortium has asked Justice Omotosho not to proceed with the delivery of the November 20th judgment, as doing so would amount to trampling upon the very foundation of the nation's constitutional order, the non-derogable right to be heard. In a statement signed by Onyedikachi Ifedi, the defense lawyers argued that the motion to arrest the judgment was lawful and constitutionally compelled acts of defense. It demands that the court obeys the rule of law before it speaks in the name of justice. Until the motion is heard and determined, no valid judgment can issue in FHC/ABJ/CR/383/2015. Justice Omotosho stands at a defining juncture, to affirm the supremacy of the Constitution or risk being recorded as a judge who pronounced judgment over silence, the statement reads. Public Briefing Note. Issued by Onyedikachi Ifedi, ESQ, for Mazi Nnamdi Kanu Global Defense Consortium. Date, November 11, 2025. Justice Omotosho must hear the motion to arrest judgment before proceeding, the non-derogable right to fair hearing and the rule of law. 1. The motion to arrest judgment is a lawful, binding judicial process. On November 10, 2025, the defense of Mazi Nnamdi Kanu filed a motion to arrest judgment before the Federal High Court, Abuja, presided over by Honorable Justice James Omotosho. That motion is not political theater, it is a recognized legal procedure in Nigerian criminal jurisprudence, designed to prevent a court from delivering judgment where jurisdictional or foundational defects remain unresolved. Although the phrase, arrest of judgment, appears in procedural legislation such as the Administration of Criminal Justice Act, ACJA, 2015, its constitutional foundation rests on Section 36(1) of the Constitution of the Federal Republic of Nigeria 1999, as amended, which guarantees every person, The right to be heard before any decision affecting his rights or obligations is made. To arrest a judgment is, therefore, to compel obedience to the Constitution, to ensure that no judgment is delivered in breach of the right to fair hearing. It is a lawful, binding, and time-honored judicial safeguard against miscarriage of justice. 2. Fair hearing is non-derogable and universally binding. Fair hearing is not a privilege granted by a court, it is the oxygen of justice itself. It cannot be suspended, diluted, or deferred, not even by judicial convenience. In Kotoy v. CBN, 1989, 1 NWLR, pt 98, 419 at 448, the Supreme Court held that fair hearing lies not in the correctness of a decision but in the opportunity afforded to be heard before the decision is made. A judgment delivered while a live motion, especially one that questions jurisdiction or competence, is pending, is constitutionally void. To ignore such a motion is to act in defiance of Section 36(1), and to deliver a verdict without legal life. 3. Why this motion matters now. Justice Omotosho has announced his intention to deliver final judgment on November 20, 2025, even though several pending motions remain unheard, including the motion to arrest judgment filed on November 10, 2025. These motions directly question the court's jurisdiction, the subsistence of any valid charge, and the validity of the plea entered on March 29, 2025. To proceed to judgment without determining them would be to pronounce upon nothingness, a legal absurdity. 4. Setting the record straight, Kanu has entered his defense. The persistent claim that Mazi Nnamdi Kanu refused to enter defense is false and misleading. He entered his defense fully within the meaning of law by subjecting the prosecution's witnesses to rigorous cross-examination, during which their credibility and the integrity of the government's evidence were demolished on record. Under Nigerian criminal procedure, cross-examination of prosecution witnesses forms part of the defense's evidentiary case. Having dismantled the prosecution's case under cross-examination, Kanu has no obligation to call witnesses in defense of a charge that itself is a nullity. What he has declined to do is to call witnesses to validate a non-existent charge, because the Terrorism Prevention Amendment Act 2013 under which he was purportedly tried has long been repealed and supplanted by the Terrorism Prevention and Prohibition Act 2022. He cannot defend himself against a mirage. 5. The legal consequences if the motion is ignored. If Justice Omotosho proceeds to deliver judgment without first hearing and determining the motion to arrest judgment, he will have denied the accused a constitutional right to be heard. He will have acted without jurisdiction, as the competence of the court remains under challenge. Any such judgment will be a nullity ab initio under established authorities including Madukolu v. Nkemdalim, 1962, 2 SCNLR 341 and Newswatch v. Atta, 2006, 12 NWLR, pt 993, 144. To deliver judgment in the face of an unventilated motion is to depart from the path of legality and to descend into judicial self-help. 6. The broader constitutional stakes. This case is not about one man, it is about whether Nigerian courts will uphold the supremacy of the Constitution. The motion to arrest judgment is a procedural shield for the judiciary itself, preventing it from issuing a judgment that would later be voided for constitutional infraction. If that shield is cast aside, judicial legitimacy collapses. 7. Our call to conscience. The Mazi Nnamdi Kanu Global Defense Consortium calls upon the Federal High Court to hear and determine the motion to arrest judgment before taking any further step. The Nigerian Bar Association to defend the sanctity of fair hearing as the lifeblood of justice. The media and civil society to resist misinformation and uphold the truth, and the international community to note that the right to fair hearing under Section 36 CFRN and the African Charter on Human and People's Rights, Cap A9 LFN 2004, is non-derogable and binding. Justice Omotosho stands at a defining juncture, to affirm the supremacy of the Constitution or to risk being recorded in history as the judge who pronounced judgment over silence. 8. Conclusion. The motion to arrest judgment filed by Mazi Nnamdi Kanu is a lawful and constitutionally compelled act of self-defense. It demands that the court obey the rule of law before it speaks in the name of justice. Until that motion is heard and determined, no valid judgment can issue in FHC/ABJ/CR/383/2015. To proceed otherwise would be to trample upon the very foundation of Nigeria's constitutional order, the non-derogable right to be heard. Signed, Onyedikachi Ifedi, ESQ, for Mazi Nnamdi Kanu Global Defense Consortium. Abuja, Nigeria, November 11, 2025. Stay tuned and have a blessed day.
Supreme Court said do something, you will do it. And you are just sitting conviction. And you wonder why God cost you people. Useless black people. You don't know what justice means. You have no idea what justice means. You don't know what justice means. Useless black African people. You don't even know what justice. Your constitution says you cannot try anybody unless the law is written. Show me the written law. Show me the written law. I want to know the written law. Don't touch me now. Show me the written law. Are you okay? Don't go close. Don't try that rubbish. Don't try it. Don't try it. Go ahead and say don't try that rubbish. Don't try that rubbish. Useless people. You don't know law. You don't know law. Your own constitution you don't respect. Supreme Court judgment you don't respect. Then why are we in a court of law? Why are we in a court of law, I ask? Nonsense. You think Britain can ask you to jail me and you jail me? You are dreaming. You are dreaming. I'm telling you that you are dreaming. Nonsense.